Hello everyone, welcome back to my channel. My name is Sandy Heron. Now in today's video, I will be speaking to attorney at law, Ewan Simpson. He has a Master of Laws in Intellectual Property and he was called to the Jamaican Bar in 2004. He is trained and certified as a public procurement professional, accredited in corporate governance as well as project management and civil aviation management. He's a team leader with a diverse but focused skill set. Now, which better person to come on today to talk to us about this very important topic that we need to think about when we are setting out to express our creative ideas. Guys, remember to like, share, comment, and subscribe. So, Ewan, thank you so much for being on the channel today.
An absolute pleasure.
Yes, and for talking to us about an area of law that I think is so important. So the first thing that I want to ask you on is, of all the areas of law, why did you choose intellectual property to specialize in?
It's an interesting question because I get that question actually quite often. And it's really a no-brainer for me because I was always involved in the creative industries. I grew up around music and entertainment and cultural practices and all of these things. Came through high school, came through the choir, went to university, did the university singers, then went to the NDTC. So I was involved in dance theater and all of these things and adjudicating music and performing and doing productions at the same time. So that was around me for my entire life growing up. And so when I went into law, I really went into law to augment the skills I already had and to support the work I was already doing in the cultural and creative industries. So it was, as a matter of fact, when I started law, there was not a lot of practice in intellectual property. There was not even intellectual property being taught at the university. So it came afterwards. And then thankfully I got a chance to go to Italy to do my master's and all of that. So it was a wonderful journey that took me there, but it was really natural fun.
Okay. And when people think about intellectual property, it is not an area that is easily understood. So in a layman's way, for someone to understand, what is intellectual property?
Intellectual property is that which comes from the creativity of your mind that you have reduced into tangible form. That is to say, you have an idea that you have manifested in a physical way so that other people can in fact see it, perceive it, enjoy it, experience it. So that is the simplest way to put it. I normally tell my students at the Institute of Caribbean Studies that it is really the tangible manifestation of the creative imagination. But then that is in the academic context, right?
Yes.
But straight layman, it is an idea that is manifested in a tangible way.
Okay. And I like that you have said that because now we have so many people doing YouTube videos, people all over doing TikToks. You have people writing.
That's right.
It's easier now to even self-publish. So this is something that is important for us to understand so that we know how to protect these creative ideas that we have and that we're putting out. So from
Absolutely.
a legal standpoint, Yuan, so let's get to the meat of the matter. If specifically we are thinking about writing a book, publishing a book, for example, what are some of the things that we should think about legally in order to protect what we have or our ideas?
Well, there are several things. There's a myriad of things that we need to think about. And again, it depends on the avenue through which we're publishing. So if we're self-publishing, there are some things that we need to be immediately concerned about. And if we're going through a publisher, then there are other concerns. So first of all, we need to determine who is to own this work. Is it going to be me, the writer, you, the writer? Is it going to be a work that you have co-written with somebody else? Are you going to be using material from someone else's work? If you're going to be using material from someone else's work, you will need to get permission from them. You'll need to get a permission in writing, which we call, strictly speaking, a license from them to use a specific portion of their work in a specific way. Depending on how the collaboration works, depending on how you put them together, it may become a joint work. And therefore, you must understand that that work is now owned by not just you, but by you and whomever else has collaborated to put that work together. Good? Are you doing the work as a commissioned work? Is it that someone has hired you to put that work together? What are the terms of that commissioning agreement? Are they expecting to own that work? So for example, if you're doing it as a ghostwriter, or you're coming on as a collaborator, or, you know, there's so many different contexts in which people write. So you need to decide where is the ownership to fall, because everything else after that will depend on the answer to that question. So we need to make some decisions about ownership. We need to make some decisions about how we're going to share the rights that surround the work. So for example, are we going to do the work to be printed in paperback only? Or are we going to do it so that it can be digitally presented? And if it is being digitally presented, is it being digitally presented just in text? Or is it going to be presented in voice? Or is it going to be, is it going to become something that's presented on video? Or is it going to become a screenplay? Or is it going to, so there's so many other things that we need to think about as we go along. It sounds complex, but it is really a logical sequence of things that we need to think about that a lot of people just don't consider. They're just writing something and they're putting it down. Bearing in mind that intellectual property around books, generally speaking, is copyright. And copyright does not require registration to be protected. So once the work is fixed, that is to say, once the ideas from the book have come from your head and it is now on a manuscript, it is protected in most countries in the world. Good. And also I need to also suggest to you that intellectual property is protected in different ways in different countries, but there are some general standard provisions. So one of them, for example, is that the work does not need to be registered normally in most countries for you to be protected. So once you can prove that you are the person who wrote it down, once you can prove that it came from your mind and you wrote it down, that is one surefire way of having that work belonging to you. So we think about that, and we think about the collaborators. Are the collaborators, if their persons collaborating with you, are they under an agreement for writing with someone else? If they're under an agreement for writing with someone else, what are the terms of that agreement and how does it affect your rights in that book? These are the things you need to think about. So if you're going to give it to a publisher, let's say, okay, I'm not going to self-publish now. I want a publisher to do it. What are the rights of the publisher? What are the rights of the illustrators that we're going to need for this book? And of course, remember, we're just talking about text now, because if we go back to the other things I discussed before, it gets even more complex. Because the person who's going to voice it, if it is going to be an audiobook, that performance of that person in the audiobook is another stream of rights. Good. So and if it becomes video or film, that's another series of rights again. So we need to think about the rights that we have and the rights that we wish to give. So these are decisions we need to make. The more we think about them and we are very clear, it is the easier it is for us to chart a course for income generation along the way, and to make it less complex and to make it less disastrous when we're not sure what rights we gave to the left and what rights we gave to the right. And all these things start to come at us. So it's critical for us to determine, what is it that I really want? What is my objective? If my objective is to get my book as far and as wide as possible, what is the best route? Who is a good publisher that I can approach? Who is a good book distributor that I can approach? You know, so we just think about these things. What is it that I want from it? If I want right now just to break the barriers and I want to get my work into certain stores, I want to get into Barnes and Noble, and I want to get into all of these places, then I may have to think about finding the right publisher. And the right publisher, if I'm an unknown author, will first have to be very impressed with the work. And then, if they're very impressed with the work and they see the economic potential, they are going to want a larger share of the revenue from the work. And so they also want to go into direct a lot of what happens with the work in terms of how it is illustrated and how it is edited and all of these things that publishers take the rights to do. So we have to think about these things, and we have to sometimes divorce ourselves from the content of the work to allow the work to be manipulated and then exploited. And I always like to correct the misperception that exploitation is always a negative word. So when I say exploit the work, I mean use the work in such a way as to allow it to fulfill its potential. So we have to think about that. If a publisher is going to take the work, they are going to want certain rights. They're going to want to make certain decisions in their wisdom as to what is best for the work and what is going to make it a successful book. Right. What is going to make it a bestseller? Because that is how we measure books. We measure books by bestsellers. Yes. So if that is the point, then we have to think about what makes it economically viable, what makes it attractive to the market. Once we have figured that out and we have found the right publisher, we now have to make peace with ourselves and determine how much of the rights to this work do I want to give up to allow the work to fly. Right, and I think that is the issue that many authors have. They feel like, okay, this idea is mine, this creative idea is mine. And it's hurtful. I have read so many stories of authors who feel as if they have just given over their work without getting much in return, even if they have become a bestseller. So in terms of signing contracts and having those conversations, like what are some of the things you think we should look for? So the first thing we need to look for is a discussion on who are we signing to? Mm-hmm. Because sometimes you sign to person X and person X is actually operating on behalf of person Z. So you are here thinking, I am person A and I am signing with person X. But then X is an agent for Z. And Z is a wholly owned subsidiary of company Y. And in the agreement, anything that is signed to person X on behalf of person Z may also be owned by company Y. We have to read to see who really are we signing to. That's one. What is their history of agreements and dealings? So we have to do a little research. Is this a company that likes to say winner takes it all and they go and they take the whole hog? Or are they known to have a history of being fair and sharing in the proceeds? Because what happens, and it's a challenge with intellectual property and business globally, they will offer you the chance to become great, but what do you end up owing them in the end? First of all, you need to determine, you need to look to ensure that the contract indicates, one, a budget. What is it going to cost me for you to take this work to the level I want it to get? What do you plan to spend on it? What are you projecting that it will cost? Over what period of time? How will you recover it? And when you're recovering, while you're recovering, or after you've recovered, what is the share? What is the share that you and I are going to agree on that I will get from whatever proceeds are coming in? Am I going to only be able to earn after you've recovered everything? Or am I going to earn a little as we go along? And then when you're finished recouping, I will earn more. What is the discussion? And so we need to be able to have that conversation to say, well, you know, I'm going to give you 1 book or 2 books or 3 books, and I really can't stay hungry until all these books begin to earn. Or are you going to give me an advance? As a publisher, is there an advance that you're going to pay me? What is that advance? And is that advance reasonable in the scheme of things? So depending on how much work you've done before, how popular you are, how much your work is already out there doing promo on your behalf, or if you're just totally brand new coming in, nobody knows you, but you have amazing work, you may have a little bit more or less leverage to argue. But it's important for you to know who you're dealing with, one, so who the parties really are. Is it me and just you who I'm looking at? Or is it 4 people behind you that I'm not seeing? Who are they? One, am I dealing with a person or am I dealing with a corporation? Am I dealing with a legal body? I need to establish that, because if it is not, I might find that there are all sorts of weird things that happen with my work. Good. And I have very little recourse, because I may be dealing with an organization that really doesn't exist. And then I'm going to have to find all the individuals who are claiming to be this organization. And that again is going to be difficult. It may cost me more than it earns me at the end of the day. So that is important. Am I getting a deposit? Am I getting an advance? If so, what does that mean? How much of that is recoupable? Is that something that I have to give back if the book tanks, if it doesn't work? Is that now a debt? Or is it a risk that the publisher is taking? Just as I am taking a risk with the publisher, that the publisher will take the work somewhere to do well. You know what I'm saying? So is the risk only mine, so that if the book tanks and the publisher has decided what they're going to do in their wisdom and it doesn't work, I still owe the publisher this money? Is that what it is? So we have to think about that. Then we have to think about who are the other people who will be connected to this work. Who are the illustrators? Who are all the people who are doing layout? All the different people who are a part of this whole process. Are they going to be taken on as works for hire? Or are they going to own a piece? Because there are different arrangements that people have. Will they own a piece of the work depending on whether they have created a character? They have created a caricature of a character that now brings the book to life and makes the book this amazing thing that everybody is in love with, this figure that they are now seeing, and therefore this becomes central to the story, visually central to the story. Therefore, this illustrator now is saying, listen, I really am the one that caused this book to bust. So I believe I must get a piece of the pie, a piece of the ownership. Is that the arrangement? Or is it that illustrators are paid as workers for hire, and that's the end of the matter? So we need to know these things. Good, it's important to know that. Next thing you hear, that your book is owned by you and some other people. What is the role of the editor? How much of the work is the editor going to own? Or is the editor doing, is the editorial work also work for hire? Or is the editorial work going to be considered co-authorship? So at every step of the way, we need to think, when somebody is added to the picture, what is the relationship? Are we creating a new owner? Are we adding another owner? Or are we adding somebody to this element? If the work is to be done in several languages, who is giving the rights to the work being translated into several languages? Because each of those languages is a separate arrangement, is a separate deal, you see, intellectual property exists geographically on the world map. And so we like to say it is territorial, and the rights that are granted are territorial. So if I give you the rights to a work, to publish it in Mandarin, it does not mean that you have the right to also publish it in English. It does not mean that you also have the right to publish it in German or Japanese. So I have to know that, okay, I'm giving rights to this publisher for this work to be done in this language. That's it. Not all other languages now known or hereafter to be known, or not all languages universal. So that's a decision I need to make. Am I giving it to this publisher for all languages? Or am I just giving it for this? What is the period of time that this contract with the publisher is going to last for? How long are they going to be able to recover for? Is it in perpetuity? Or can I republish the book after a period of time with someone else if I'm not satisfied with what is happening here? And if I republish it, what are the rights that that initial original publisher will have to that work? These are all questions that we need to ask to ensure that at the end of the day, one, we are comfortable with the arrangements, and two, we have put systems in place to protect ourselves.
Yes, I think that's very, very, very important to put systems in place to protect yourself. Earlier, you mentioned copyright, and you mentioned that the work is automatically ready. You don't need to register your work, right? Often
Correct.
in books, there is a clause at the beginning, a copyright clause, which says no portion of this book may be reproduced, for example. Is it important to include such a clause to your book?
It is important, but it is not fatal if it is not there. That is to say, it is important to place a copyright notice, it is called, right? So you place a notice there. So let all who view beware that this book is not free for all, right? Please beware. Like a TV program runs on the screen, and at the end it will say copyright protected or all rights reserved, and it says to whom. Good. That gives you an opportunity, if you wish to manipulate some parts of that work, if you will know who it is that you must make contact with in order to be able to do it in a compliant way. That's really what it does. But if it is not there, well, certainly in many countries of the world, if it is not there, it does not negatize, it does not remove your rights as an author.
Yes.
Good. But of course, it's important to have information so people can know exactly where to go, who to go to, in case they need to interface with the work.
Okay. And as much as we don't want others to infringe on our rights, we want to ensure that we don't infringe on the rights of others as well. When it
Absolutely.
comes on to quoting other people in our books, what is the best way to approach that?
Well, there are some basic principles against plagiarism. There are some principles of well, depending on how it is being done. So sometimes, let me just put it this way. The right to be acknowledged when your work or portions of your work is used is a basic right of intellectual property. We call it a moral right. So the right to be acknowledged as the author of a work when it is used or a part of it is used is what we call the right of attribution. So if you use a piece of my work, my name must be called. It's a right that I have. Good. And just attributing it to me is not sufficient, especially if you've taken a substantial portion of my work and placed it in yours. You may need my permission to do so because it is my work and I must determine when it is used or parts thereof are used. Okay. So, and that again is a long discussion about what is substantial and what are exemptions to fair use or fair dealing. There's a whole discussion about fair use and fair dealing and how much is fair and in what context, whether it is in news reporting or it is teaching and instruction, private research and study, or for some other legislative purposes, or all of these things. There are exemptions. But if it is being placed in a work, if I am taking something from somewhere else and making it a part of my book, if I'm taking a photograph from somewhere, if I'm taking a quote, a paragraph from someone else's work, the very least I need to do is to attribute the work to the author, to the original author. The second thing that I need to do is to get the author's permission or the publisher's permission to include it in what I'm doing.
Okay. And does this go for example, for quotes that we find on the internet or even a stock photo?
Now, stock photos are interesting because not all stock photos are really stock photos. Some of them we buy based on licenses given by some sites or some entities who trade in photos. They have the rights to them and they give you rights to use them in particular ways. Some of those photos you are able to use them for non-commercial purposes. Others of them, if you are going commercial, it is a separate arrangement. Quotes that are written on the internet, I was to be very careful of them because some of them, somebody borrowed them from the original space. So because it's on the internet, it doesn't mean it is what people like to think of as the public domain.
Right.
Because the internet is not the public domain. Something goes into the public domain when the copyright which exists in the work has expired. That is the most fundamental way that something gets into the public domain, not because it is freely available on the internet. So if I produce a work, and those works, by the way, include sayings, wise sayings, funny sayings, just statements that I may choose to make and place it on my Facebook page. Because I've placed it on my Facebook page and all of you can read it and enjoy it, it does not mean that you can now take it off and place it as a quote in your book attributed to yourself. Because the world is going to see that I had written that on Facebook 6-7 years ago. And when I decide to sue you for having used my quote without my permission and your book has become a bestseller, don't think that I am just bad man. So good. So things are available on the internet, and if it is not expressly stated from a reliable site that these are free for use and that they are free for use in a particular context, whether for non-commercial use, or you can buy them for a small fee for non-commercial use or for commercial use, you need to be very clear what the fine print, what the user agreement of that site is where you're taking the stuff from. And when you're in doubt, find the author. When all else fails, make something up yourself. You're a creative.
Yes.
So there are lots of misperceptions around the internet. We have to be careful of it because people take things, place them there, then you believe that because I placed it on the internet, then it is mine. When I really stole it from someone else and placed it there, then you take it and you give it to someone else, and then that person attributes you as the author. And then all hell breaks loose.
Right. When you think about like quotes from like Aristotle, for example, so many persons have quoted his work. How would you treat something like that? I mean, if you're going to use something from Aristotle or Plato, who would you reach out to?
Sayings from Aristotle and Plato would have long gone into the public domain. I mean, Aristotle was probably around the time of Christ. So, right? So they would have been around from a long time ago. And so remember now that copyright protection in most countries subsists or lasts for 50 years after the death of the author. In some countries, it's 75 years. In some countries, it's 90 years. So it is not in perpetuity, it doesn't last forever. So people like Aristotle and Plato would have long gone over 100 years ago. And therefore, a lot of their work would automatically be in the public domain. Now, if someone has reversed it or reworded it, ascribed it to Aristotle, but has done a reinterpretation of it, then there is new copyright in that reinterpretation. And a lot of the things that we see that are ascribed to some of these philosophers, really they did not say those things. People have created them and said they said it, but a lot of them you see on the internet are really not, like a lot of the things that were being attributed to this African leader, and they're funny, and people ascribe it to him. A lot of them were not said by him. So we need to be careful of the sources from which we come, and we need to double check sources. So there are reliable sites, reliable encyclopedias, reliable book sites, literature sites, where we need to go to find whether some of the things we see ascribed to authors, ascribed to philosophers, ascribed to different figures, historical figures, are in fact their works.
Absolutely. There is just so much to think about and so much to do when we're thinking about our creative work, or we're setting out to do our creative work, Ewan.
Absolutely, which is part of the reason why we have to make some serious decisions when we are thinking to self-publish. Because when we go to established publishing houses, when we go to established publishers, they help us to think through some of these. They help to move away some of the clutter. They help to make some of the connections that we need to secure ourselves, but it comes at a price. So we need to determine how much of that work are we willing to give up for all of that work that they will take on our behalf, to declutter and to open doors and to put up barriers and all of these things.
Yes, and then of course, if we are thinking about doing it on our own, right? Then talking to someone like you, Ewan, is such a good start, right?
Absolutely, absolutely. It's always useful, if you are a creative, to have a conversation with an intellectual property attorney, because there are things that they will look for that you might not look for. In the creative process, I mean, being a creative myself, I know what I don't want to think about. I want to just create and I want to get it done, and I have an idea, and idea pops in my head, and I see something else that inspires me, and I want to know how much I can use of that, and I will toss it in, and somebody has to be able to say, hold up, take a break. Do you have the rights to that? Do you know where that came from? Are you prepared to deal with the consequences of using this? Somebody has to be able to say that to me. And in the same way, we cling to our creative exercise with other creatives. We have to also be careful not to cling to the way we want to express our ideas when they may put us in legal trouble.
Yes. Absolutely. Ewan, I want to thank you so much for talking with me today, sharing your expertise on intellectual property. I have learned a lot, and I am sure our viewers have learned a lot as well. So I want to thank you so much.
It's always a pleasure. Feel free to call at any time. And it's good to see you.
It's good to see you too. Thank you.
No problem.